Late last week, a federal court heard arguments over Justin Trudeau's decision to prorogue Parliament. The lawyers involved launched their case to argue that there should be a limit on when Parliament can be prorogued. Meagan Gillmore, reporter with Canadian Affairs, has more on the case.
So this case is specifically about the current proroguement. So lawyers for two representing like two individuals who put forward this complaint are saying that the current proroguement of Parliament is unlawful, particularly given our situation with the US. So this challenge was begun after Donald Trump started making threats about tariffs. So that's one of the reasons. And then another reason that they drew upon a lot before the for the federal court was the reasons that Justin Trudeau gave on January 6th in his press conference. So his reasons about Parliament being at a standstill, that nothing can really happen, and that he's proroguing Parliament so that there can be a Liberal leadership race. Now, lawyers for the government are going to quibble about whether or not those were the actual reasons for proroguement, but it is specifically this proroguement that they are questioning whether or not it is lawful. And in terms of the law, they would rely on the section of the charter that talks about your right to vote. And they would say that currently their clients are not being represented by any member of Parliament because Parliament is not in session. The judge decided to hear the case and decided to hear it quicker and an expedited manner. So the reasons for hearing the case faster than normal are a couple. One is we have a timeline, right? Like proroguement is only lasting until March 23rd, I believe. The Liberals will vote for their new leader on March 9th. So if the court had done the regular timeline for hearing this case, proroguement would have been over. It would have been a moot point. So that's one of the reasons to expedite it. The other one is about what's happening in the US and the economic threat that tariffs could pose to Canada if they are imposed. So it's a combination of just our timeline with proroguement, and then also what's going on in the US. So the argument against the courts weighing in is essentially that this is outside of their jurisdiction, that decisions to prorogue are political in nature. They are rooted in unwritten constitutional principles. There is no strict matter of law for the court to weigh in on. The concern that was raised by lawyers for the government and then also an intervener siding with them is that if the court weighed in on this decision, the court would be becoming inherently political, and that would undermine, or could undermine, sorry, the trust that Canadians feel in their judicial systems, in their courts. That's really the big argument. There's also an argument that would say that the Prime Minister does not make the decision to prorogue. The Governor General makes the decision to prorogue on the advice of the Prime Minister. Lawyers will go back and forth about that because in practicality, the Governor General follows the Prime Minister's advice to prorogue. So while I was saying earlier that the lawyers for the plaintiffs were pointing out that, well, for the applicants, sorry, were pointing out that Justin Trudeau's decisions that he gave on January 6th in his press conference were not lawful reasons to prorogue Parliament. Lawyers for the government would say that might have been what he said in a press conference to all of Canada, and that his wording might have been, I'm proroguing Parliament so that we can have a leadership race, but the actual technical decision to prorogue is made by the Attorney General. I mean, sorry, not by the Attorney General, by the Governor General, Mary Simon, when she agrees to prorogue Parliament.